Welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. My name is Maitreya Brown, and I'm going to talk about the K-1 Fiancé visa frequently asked questions. You're not going to want to miss out on this one. Thanks for tuning in. My name is Maitreya Brown, and I'm a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration information that could be vital to your case. And also, be sure to stick around until the end to get a bonus tip on what you can do if your K-1 Fiancé visa is denied. Now here's a big one. What is the K-1 Fiancé visa? So the K-1 Fiancé visa is a non-immigrant visa granted to the foreign fiancé of a U.S. citizen to allow him or her to enter the U.S. for the sole purpose of marrying the U.S. citizen within 90 days of his or her entry on American soil. Another question is, do I need a lawyer for a K-1 visa? So no law in the U.S. states that you need an attorney to file the K-1 visa application. However, the main cause of delay and denials in K-1 visa applications is inaccurate and poorly prepared applications. So when you hire an immigration attorney to represent you, you decrease the strain and insecurity you experience as you go through the process. Another question is, can I get a K-1 visa if I have had some criminal history in my home country? Now, criminal history can become a serious obstacle in immigration to the U.S. However, it does depend on the severity of the crimes committed. Now, these crimes would need to be expertly examined to determine the likelihood of your ability to immigrate to the U.S. In tandem with this question, another question is, what if my U.S. citizen spouse has a criminal record? So the type of seriousness of the criminal record, whether they are arrests or convictions, will determine whether your spouse can file a fiancé petition on your behalf. In some instances, a waiver must be filed to allow the filing. And it is important to reveal this information to our law firm when you consult with us so that we can properly assess whether a K-1 visa is the most viable option for you. Another question I often hear is, what if my fiancé has children? Can they immigrate with him or her to the U.S.? So if the foreign fiancé has unmarried children under the age of 21 living with them abroad, then they may be eligible for the K-2 visa to enter the U.S. with their parent. Now, they must be included in the original petition to USCIS, and they must travel either at the time or after the K-1 visa holder enters the U.S. Another question I get is, what does a K-1 visa medical examination involve? So every applicant must undergo a full medical examination by an authorized medical physician. So the medical examination will include a review of the applicant's medical history, physical examination, chest x-ray, and blood tests. The physical examination will at least include examining the eyes, ears, nose and throat, extremities, heart, lungs, abdomen, lymph nodes, skin, and external genitalia. There are several steps involved in seeking a medical examination. The doctor that carries out the test must be permitted to do examinations for immigration purposes, and you must inform the doctor that the medical test is for immigration purposes. At this step, you will incur separate costs for the medical exam. Another big question is, can I work with a K-1 visa? So yes, you can apply for work authorization by filing Form I-765, which is the application for employment authorization before you can work. And like the K-1 visa, this employment authorization is only valid for 90 days, starting from the day you arrive in the U.S. If you choose to apply for permanent residency after you arrive and file Form I-485, which is the application to register permanent residence or adjust status, then you can also include another Form I-765 with your application, and this would grant you work authorization for a year. Another question is, how long is the fiancé visa valid for? So the K-1 visa is valid for a period of 6 months, and this means that the foreign fiancé can travel to the U.S. within 6 months from when the visa is issued. However, once they have entered the U.S., they can only remain for 90 days. and if they are not married within that time frame, the foreign fiancé must exit the U.S. Now, suppose you fail to get married within 90 days. In that case, the foreign fiancé and any children included in the original petition must leave the U.S. Failure to depart violates U.S. immigration law and can lead to deportation. And any future eligibility for U.S. immigration benefits may also be negatively affected. And please note that the K-1 visa holder may only appear for a green card based on their marriage to the petitioner, though other options may be available if they are married after 90 days, but typically you do want to stay within this timeline of being married within 90 days and then filing for the green card application based on your marriage to that petitioner. Another big question is, if my partner is a green card holder and not a U.S. citizen, can I still apply for the K-1 visa? So, as previously talked about, the K-1 visa is only open for fiancés of U.S. citizens. So if your partner is a green card holder, they will be able to petition you for your entry if you are already married, or if you're not ready to get married just yet, perhaps you can wait for the green card holder to become a U.S. citizen, then become engaged, and then go this route of the K-1 fiancé visa. Another big question is, how do I apply for a green card after I've entered the U.S. with a K-1 visa? So suppose you have entered the U.S. on a K-1 visa and are married to your partner. Congratulations on starting your new life together. So to apply for a green card, you must file Form I-45, which again is the application to register permanent residence or adjust status. Another question that we receive is, do I need an affidavit of support for the K-1 visa? And the answer is yes. You will need to submit Form I-134 when applying for a K-1 visa. Another big question is, what is the difference between the K-1 visa and the K-3 visa? So if you are the fiancé of a U.S. citizen, then you can apply for a K-1 visa. If you are the spouse of a U.S. citizen, then you can apply for the K-3 visa. Both visas are available only to partners of U.S. citizens and not green card holders. Another big question is, my K-1 visa has been affected by COVID-19 restrictions. Is there anything I can do about it? So according to USCIS, consular posts have been authorized to prioritize K visas. So you should check on the website of your nearest U.S. embassy or consulate for the latest information. And if your U.S. citizen partner has filed Form I-129F, which is that petition for an alien fiancé for you, and this petition is set to expire, you may be able to extend the form and avoid having to file a new petition. And last but not least, another big question is, why would my K-1 visa be denied? So some activities may make you ineligible for a visa, and examples of these ineligibilities can include drug trafficking or submitting fraudulent documents. Fraudulent documents can include false dates of birth or false financial records, so make sure you're very careful when preparing the applications, and also try not to have a criminal history. As promised, here's some bonus information that you may not know about. So let's talk about legal motions. So in case of a denial, in many cases you may be able to file one of two legal motions to have your case reviewed a second time. Now the first option is a motion to reopen, and this is used when documentation or evidence has come to light that may change the outcome of the fiancé visa case should it be reopened. The second option is a motion to reconsider. And this is used when you and your immigration attorney believe that the evaluating officer was incorrect in his or her decision. And you can demonstrate this through a legal argument. Now, because they require legal expertise and arguments, neither of these routes should be taken without having an immigration attorney to assist you. And this is the best way to successfully overturn a fiancé visa denial. I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.